Good morning, my lords. I appear together with Mr. Hooper on behalf of the Appellant, Inc. Mr. Barden, to my left, appears on behalf of Mr. Frenkel. And then for Mr. Bell, an LA Micro Group UK Limited, instructed by Mr. Twigger of King's Counsel, Mr. Strelitz and Mr. Himes.
Very good.
My lord, sorry.
No, just say what you were going to say.
Thank you. In respect of Mr. Liampa, there is no representation from him. He's not taking part in respect of this appeal. My lords, we've been discussing potential timetabling, both of issues and also of the time over the 2 days. Obviously, all subject to your lordship's views. And we've agreed, again, subject to your lordship's views, that in respect of issues, it will be more appropriate to take the issue of proprietary estoppel first, followed by the appeal in respect to the implication of the implied term, and then finally issues of constructive trust.
Yeah, do you mean have it, as it were, here separately from each party on those issues?
Well, the way that the appeals took place involved proprietary estoppel, constructive trust, and then implication of implied terms. Obviously, implication of implied terms has a direct relevance to constructive trust as to whether that's even an argument, so we've simply swapped those two around. In respect of timetabling over the 2 days, what we propose is for myself to address the court on proprietary estoppel this morning and implied terms, Mr. Barden to then follow, potentially going slightly into the afternoon session. Then Mr. Twigger to provide his response on proprietary estoppel and implied terms in the afternoon, and then moving on to constructive trust. Before, on the Friday, noting your lordships will be sitting at 9:45, Mr. Twigger to continue, presumably with constructive trust in the morning for, say, a further hour and a half. Then for myself, Mr. Barden to provide a response or reply to proprietary estoppel and implied terms, and then a response to constructive trust for the remainder of that morning and slightly into the afternoon, before Mr. Twigger then provides his reply on constructive trust.
All right, well, if that's what you've agreed, then so be it. In our discussions before coming into court, we had thought that it might be simplest if you were simply to make your submissions on everything, followed by Mr. Barden, who we envisage will probably not have a great deal to add, since there's no really separate points which he has, and then Mr. Twigger, and then your reply. But if you think it would be more helpful to us to break it up in the way that you've had there, you suggested, then by all means, let's go along with that.
Thank you, my lord. I think that the issue being in respect of constructive trust is as to actually how it's put by UK and Bell, and it might be that my responses to that can be quite short.
Yes. All right. Well, let's proceed as you've agreed. You're between you more familiar with the case than we are at the moment. So
thank you, my lord.
Hopefully that will be the best solution.
By means of other housekeeping matters, authorities, I'm working off a hard copy. Mr. Twigger and I think Mr. Barden are working off electronic copies, but all references I'll be providing are to the hard copies and the internal page numbers of those authorities.
Right. It looks as if we're all working off hard copies as well.
My lord, in respect of Inc.'s submissions, it obviously relies in full on the skeleton arguments as filed. I don't know, obviously your lordships hopefully will have had an opportunity to consider those in detail. In respect of proprietary estoppel, there are 2 points made which, once they're boiled down, are relatively simple. My lords, they go to the question, firstly, as to whether there was actual reliance by Mr. Bell on the Frenkel disavowal, in the sense that he had a state of mind that he believed that Inc. was giving up its interest in UK. That beneficial interest being the property which is the subject of the estoppel. There is then a secondary point, my lords, in respect of unconscionability. We raise that to demonstrate a further basis upon which the judge's treatment of proprietary estoppel is inconsistent with other aspects of his judgment, and in particular the issue of laches. In respect of proprietary estoppel submissions on behalf of Inc., on the question of reliance, what I was proposing to do is just give an overview to your lordships as to what we say. Then moving on to deal with certain specific points in time and how those points in times have been dealt with in the various judgments. Those points in times being the 2004 agreement and how the previous judgments have dealt with the issue of the trust arising thereunder. The state of mind of the parties immediately prior to February 2010, that's the date of the first Frenkel disavowal as it's been defined. Events in early 2010, and then the subsequent conduct. My lords, in respect to the subsequent conduct, I won't go into that in detail. Mr. Barden wishes to address the court on that, and rather than hearing twice, I'll leave most of the submissions in respect to the subsequent conduct to Mr. Barden. After dealing with those 4 points in time, I then propose to go on and deal with how the court below dealt with the issue of contractual surrender by reference to its reliance upon the subsequent conduct. Then, as to how the court dealt with the issue of proprietary estoppel and reliance, to submit to your lordships that there is a clear inconsistency within the judgment as to reliance. I'll then deal then briefly with the issue of unconscionability. My lords, in respect of the summary on reliance, I don't identify any difference between the parties as to what the question was before His Honour Judge Jarman, King's Counsel, at Trial 2. The question was whether there was reliance by Bell on assurance by Inc. that Inc., not Frenkel, but Inc., was giving up its interest in UK, that interest being the property in issue. Secondly, there also doesn't appear to be any difference between the parties, that in answering that question, it's a question of fact, the court asking what was the state of mind of Bell. And finally, my lords, the burden of proof in respect of that element of proprietary estoppel rested on Mr. Bell. In respect to this appeal, Inc. clearly accepts that this is a challenge to a finding of fact. But we do say that in this case, there's nothing difficult about that appeal because the judgment contains fundamental inconsistencies. My lords, in respect to those inconsistencies, the court, in the earlier part of its judgment, dealt with an argument of contractual surrender raised by Bell and UK. In dealing with that issue, the judge found, as a matter of fact, that there were no discussions about ownership in 2010 between Mr. Bell and Mr. Liampert. The reasoning for that finding was reliance upon Bell's subsequent conduct. I.e., did Mr. Bell believe that Inc. was the owner both at and then after 2010? And my lords, the subsequent conduct, we say, goes to show that, at the very least, Mr. Bell was confused, or that he did believe that Inc. was the owner and that that position was not affected by the Frenkel disavowal. But particularly, the judge, in dealing with contractual surrender, and in particular whether there was an express term that ownership would change, relied upon the subsequent conduct to decide what happened, as a matter of fact, between Bell and Liampert in that early 2010 period. That was in the context in which, as I'll explain and show to your lordships, there's clear findings that what was said between Mr. Liampert and Mr. Bell was that Mr. Liampert was going to carry on with Inc. Mr. Liampert said that to Mr. Bell, and it was their joint intention that between them that Inc. and UK would continue to trade together. Further, that in Mr. Bell's mind, Inc. and Mr. Liampert were interchangeable, and in circumstances where Mr. Bell had no real regard or understanding of corporate structures. For completeness, I don't raise that as a criticism of Mr. Bell, but it is a finding within the judgment. It's on that basis that His Honour, His Lordship, determined that as of 2010, and that as a matter of fact, there was no discussion between them as to ownership, having placed reliance particularly on the subsequent conduct. We then move on to the issue of proprietary estoppel and how His Lordship dealt with that issue. There, he then essentially flipped the argument, held that there was actual reliance by Mr. Bell on the Frenkel disavowal, and in doing so, he discounted that subsequent conduct as not being relevant as a matter of fact to what took place in 2010, despite having previously relied upon that same conduct to determine what was said in 2010. Hence we say, in very simple terms, there is an inherent inconsistency within the judgment. Further, that in respect of how the judge dealt with the issue of proprietary estoppel and reliance, his judgment is confused in its reasoning in circumstances where what the judge is identifying is an assurance not that Inc. was giving up its interest, but rather that Mr. Frenkel was walking away. That Mr. Frenkel was out of the picture. And that was what was important to Mr. Bell, because he did not wish to be stuck between, quote, two warring parties. That is what he believed to be the position in respect to the Frenkel disavowal, in circumstances where, as his lordship found, Mr. Bell, in his own mind, considered Mr. Frenkel, both Mr. Liampert and Inc. to be, quote, interchangeable. So we say that there is a fundamental inconsistency within the judgment. And therefore, on that basis, there was no reliance, there was no finding of reliance, and therefore the claim on proprietary estoppel should have failed. My Lords, moving on, in respect of legal points, we at the moment don't identify any differences between ourselves and Mr. Bell and UK. To the extent to which they do become apparent, I'll propose to address those in my reply. My Lord, moving on now to the events, there's 4 points in time I wish to address the court on. These have relevance not just for the issue of proprietary estoppel, but also implied terms and also constructive trusts. The first point in time is what took place in 2004. My Lords, there's no dispute between the parties that an agreement was reached in 2004. That's a quadripartite agreement involving Bell, Liampert, Inc. and UK. That had 3 elements. The first was preferential trading relationship between Inc. and UK, such as sales at costs and non-competition. The second element was the profit share, which was to be 50-50. 50% of profits to Inc., 50% to UK. And then the third element was the one of ownership of UK, with Inc. owning 51% and Mr. Bell 49%, thereby providing Inc. with control. My Lords, in respect of Trial 2, what was argued by Bell and UK was that those 3 elements were indivisible. So that if one or 2 of them came to an end, then the third element must also come to an end. And in particular, in the event of the preferential trading ceasing, and the profit share to cease, then ownership would also cease. That was the argument that was put forward.
Can I go back a moment? in relation to the profit share, you said the agreement was that 50% of the profit would belong to Inc. and 50% to UK.
Yeah. 50%. Yes. Well, 50% to Bell. Forgive me. Do apologise.
Well, that's what I wondered, because on that basis, Mr. Bell would only get a quarter of the profit.
I appreciate. I do apologise. Yes, it was Mr. Bell.
The other question I had was, when was UK incorporated?
UK was incorporated prior to the agreement, and it was originally registered under a different name. From my recollection of the facts, my lords, and I'll be corrected if I'm wrong, Mr. Bell that company had already been incorporated prior to the agreement. Mr. Bell had been registered at that point as the one shareholder in it and was the director, and essentially bought it off the shelf, renamed it for the purposes of this 2004 agreement.
Yeah. Okay. Thank you.
Thank you. My lords, could I ask you to please have a look at the judgment below, which I'll call the second judgment, which is in the core bundle behind tab 9 and page 205. This is paragraph 26. This is how the judge dealt with the issue of whether the three elements were indivisible or divisible. And what he does within that paragraph is determine and find that the three elements were divisible. It did not follow that the parties agreed, accepted, or understood that if the profit share element ended and or the preferential trading ended, the ownership would therefore change. The three were therefore not inextricably linked. And that he provides certain reasonings as to why that was the case.
I mean, profit sharing and ownership are linked to some extent in any case, aren't they? Because even if there is no longer a formal profit sharing agreement, you'd expect to get your share of profits by way of the dividends that will be declared. Now, I appreciate not all profits might be declared as dividends, but to the extent that they were,
as a matter of commerce,
you get the dividend if you were the owner of the share.
My lord, if you are an owner of a share, then you should, as a general principle, receive the profits, but it doesn't always follow that that is the case. In business, I would submit that there can be various arrangements entered into between parties as to how profits from commercial enterprise could be, in a way, divvied up and distributed. That it doesn't follow that, for example, if A and B, A owns a business, A agrees that from respect to that business he's going to provide, say, 25% of the profitability of that business to B, whatever terms, that it follows that B must therefore acquire ownership to the extent of 25%. It's a potential. It's fully accepted that that's a potential route, but it's not the only route. It's not a necessary route for the two to go together. My lords, that was the finding of his lordship below, and that's the point that has not been appealed. Further, the argument on contractual surrender extended to an argument that in respect to that 2004 arrangement, there shall be implied into that agreement a term that required the issuing of further shares so as to reflect the 49-51% ownership agreement. That was an argument that was put forward based upon an implied term. His lordship dismissed that argument and rejected it, as set out at paragraph 34 of his judgment on page 209. As per the final sentence, his lordship held that such a term was not necessary to make the agreement work, and indeed the agreement did work without the issue of more shares. So that underlines the point that there was no connection between the issue of ownership and profit distribution, profit entitlement. They didn't go together. They didn't have to go together. So it is entirely consistent.
I thought it was a different point. I thought that at this stage in the judgment, it's accepted that the agreement was that there'd be 51%, 49% ownership. The issue was that to be given effect to by the issue of shares in those proportions, which is what you would expect in a well-run company, quite frankly, or not? If not, then it necessarily follows, and I didn't understand this to be disputed, that the one single share that Mr. Bell held must have been held by him on trust for the parties in those proportions.
It was held on trust, but what was said, and this goes to the issue of whether that trust was a constructive trust or express trust. So what was being said was there was an implication that there was a requirement for further shares to be issued. So therefore, the holding of the one share by Mr. Bell originally was not on an express trust, but was on a constructive trust basis, because it was pursuant to enforceable contractual obligation for further shares to be issued. That was the way it was put, my lords. So what his lordship...
Yes, but as I say, I don't think that has anything to do with the disconnect between the 50-50 split of profits and 51-49% of ownership. It's a question of what mechanism was agreed to give effect to the 51-49 ownership.
But it underscores, my lord, I would submit it underscores the point that there was no requirement for that ownership to essentially be corrected so as to recognise 49-51 in the issue of shares. I understand your lordship's point that it doesn't go directly towards the issue of the indivisibility or divisibility, because that had already been determined. But it was a point in respect of there was no requirement for the implication of a term in those circumstances.
I'll have difficulty with this. Something has to be. It's not suggested that the parties sat around a table and said, your one share that you hold, Mr. Bell, and any share that subsequently gets issued will be held on express trust for A and B in these proportions. What they agreed, what is a finding that they agreed, was that the company would be owned 51% by Inc. and 49% by Mr. Bell. That's their actual agreement. The question is, how do you give effect to that? And as I understand paragraph 34, what the judge is rejecting is the idea that it's implicit in that the parties agreed that more shares would be issued in those proportions. Once you've rejected that, the only other way of giving effect to that agreement on ownership is that the share that has been issued, and any future share that's issued to those parties, is necessarily held on trust for the parties in those proportions. That's all, and that's all that he's deciding. But that seems to me to have, with respect, nothing to do with the question of whether the contract is divisible or indivisible, or is it all bound up with the division of profits or not. It's just a question of what mechanics are used to give effect to the finding that there was an agreement as to the proportions in which the company would be owned.
Yes, my lord, I accept that point.
So I'm not sure what help you get from 34, to be honest.
My lord, if I continue there. I was therefore going to move on to the point that your lordship just made as to the basis upon which the first share and then the second share were held, which his lordship found was on pursuant to an express trust and not on the basis of a constructive trust. That's in paragraphs 57 to 58 of the judgment. Hence, the first share, the original share, was held by Mr. Bell as a trustee, holding 51% of that share beneficially for Inc. And in respect to the second share issued in approximately 2008, Mr. Liampert was the trustee holding that share beneficially for Inc. 51 and Mr. Bell 49. My lords, moving on to what were the parties thinking immediately before the Frenkel disavowal. The Frenkel disavowal occurred in two conversations, one in February and one in March 2010. As to their states of mind, in respect to Mr. Liampert, I think everyone accepts, and it's not controversial, that he always believed, as a matter of fact, that he owned 50% of UK, and that ownership had nothing to do with Inc. That's his position both prior to February 2010, but also for completeness thereafter. My Lords, that is consistent with paragraph 41 within the judgment, in his Lordship's recording of what evidence was given by Mr. Liampert as to his state of mind.
Is that in 41, that's what he believed before Mr. Frenkel said anything? In other words, right from the time the share was first issued, he thought he owned...
Yes, my Lord, that's the position. And that was the position within the 2015 proceedings that Mr. Liampert took. He took the position that it was his share all the time, and therefore he was the 50% owner of Inc., of UK, forgive me, by virtue of his shareholding.
Was that from the date when it was issued to him, or from even before, from 2004?
Well, it wasn't issued to him in 2004.
Yes, but somebody must have owned the company in 2004. We know there was one shareholder, which was Mr. Bell. Are you making submissions to what Mr. Liampert thought the ownership of the company was in 2004, or only once the share had been issued to him?
He thought that he was at all times 50% owner of.
So from 2004.
And that was the position he took in front of Mrs. Justice Tipples, as she is now, in the 2015 proceedings.
So in his case, the issue of the share to him in 2008 or 9 simply reflected what was the agreed position throughout.
Yes, my Lord. And the parties' positions in respect to the 2015 proceedings as to what they all respectively understood was set out in the Tipples judgment at paragraph 16, which I can take your Lordships to. This is at Supplemental Bundle, tab 10, page 57. There was an issue as to who were the parties to the agreement, and then also as to what was agreed as to ownership.
That seems to suggest that Mr. Lampert's case before her was that he owned 51% of the company at the outset, not 50.
Yes, my Lord.
You said that his case was he believed 50%. I know the difference between 50 and 51 is not very significant, but it does help to be precise as to...
Yes, I do apologise, my Lord. It's my error.
I mean, looking at what she says in paragraph 16, by then there was no dispute that Mr. Bell would have 49% in 2004. The dispute is over the remaining 51. Is that...
My Lord, that's the position within paragraph 16, but the difficulty is in paragraph 41 of the second judgment below, Mr. Liampert's actual evidence was that he believed he was just the owner of the single share.
Right.
Okay. In paragraph 18 of Ms. Tipples' judgment, it says Mr. Lampert's case is based on the assertion he agreed that they would own the UK company 51.49, with Mr. Bell owning 51%. Is that the wrong way round, or is that what he said?
My Lord, there is findings as to what Mr. Justice Tipples decided, which might assist the court. I mean, the position in respect of the 2015 proceedings, that they were highly contentious. I think the parties' positions did move over time within those proceedings.
Are you able to assist, maybe or not, with my Lord's question as to whether, when in the first sentence, Miss Tipple says Mr. Lampert's case was that Mr. Bell owned 51%, whether that was his case or whether that's just an error in the judgment? And what was meant was that Mr. Lampert owned 51%.
I think it's accepted that that's an error. It should be
That's an error in the judgment.
Error in the judgment.
Right.
Yeah, I mean, it looks as if it is because it's inconsistent with paragraph 16.
Exactly.
Yeah.
My Lords, if it helps, Mr. Strelitz, who was actually there, tells me that it was an error and it should be the other way around.
Thank you very much.
Anyway, so what we have is that Mr. Lampert's case before Miss Tipples was that in 2004 he owned 51%, but in the judgment under appeal, as you say at paragraph 41, by 2010 he thinks he owns half.
Yes, my lord.
He owns 50%.
Yes.
He just owns his share beneficially.
Yes, my lord.
Shows a degree of confusion, perhaps on his part.
It's difficult to know whether he recognised that would be recognised by him as confusion. Right. And the point being is that was his evidence that he owned that share and that was his entirely.
Well, as my Lord says, there is quite a difference between 50 and 51 for obvious reasons.
Yes, my lord, I fully accept that.
Sorry, I interrupted you.
Moving on to the position of Mr. Frenkel, there is no finding of fact as to what he believed. I've not identified a finding of fact as to what he believed to be the position as at February 2010. But again, from the 2015 proceedings, he asserted that he was a 25.5% owner of UK. And that was also recognised by Mr. Bell and UK. My lords, you'll have seen reference to a letter as part of the subsequent conduct sent by Aaron White, solicitors for the claimants. My lords, that's within the supplemental bundle, tab 8, page 38. This was an open letter sent setting out Mr. Bell and UK's position. And my lords, you'll see on that first page their understanding of what the different parties were arguing as at the date of that letter.
That presumably was taken from the pleadings in the 2015 litigation, which hadn't yet come to trial. They came to trial in 2017.
My lord, I obviously don't know the basis on which those instructions were given internally within the claimant's legal team. I mean, all that one knows and one can assume is that that was based on instructions from Mr. Bell and UK as to what their understanding was of the respective parties' positions and a statement of his positions, because it was sent by his solicitors, presumably on his instructions.
I'm looking at the previous sentence, previous paragraph.
Oh, yes, my lord, but again...
The individuals have set out in their statements of case 3 different interpretations. So this is just a reflection, is it not, of the parties' pleadings in that action?
It would appear to be, but I can't...
Do we have the statements of case in that action?
I don't believe within the trial bundle, my lord. Within the appeal bundle, my lord, we don't.
But certainly, unless someone's going to say otherwise, I would just assume that was what the parties had pleaded.
My lord, I was answering the question on the basis whether I knew that was
Yeah.
the position, which I fully accept, that you have a a piece of litigation in which there are statements of case, there were movements in respect to the party's evidence, certainly at trial, etc. So I don't know at what point that statement was made as to what was the basis for it. It is stated to be the statement of case, but I can't state that that's correct or not, clearly. But what it is a clear manifestation from the claimants as to what they understood to be the other party's positions, but also what Mr. Bell and UK's position was.
Yes.
That is without a doubt. And that's part, my lord, of the laws of the subsequent conduct, which is something which has flowed through both trials in respect to this matter. My lords, grateful to Mr. Hooper, behind tab 7 of the supplemental bundle there is Mr. Bell and UK's defence. At page 37, there is a paragraph 21 denial that the claimant, being Mr. Frenkel, is entitled to relief claimed or any relief at all. Any relief could only be made in favour of Inc.
Indeed, paragraph 7D that your Lordship is going to look at.
My lords, if I shall move on to the position of Mr. Bell.
Well, just while we're looking at paragraph 70, it looks to me as if that refers to the position in 2004, because it's a paragraph which starts talking about causing a company to be incorporated.
My lord, the point I think is that in respect of how they plead it, they plead the position as of 2004, and they don't plead that there was any change in 2010 as a result of anything which occurred, and that's why they're saying in 2015 that the only entitlement to relief as of 2015 is an entitlement on the part of Inc.
Where does it say that? I'm sorry.
There's no identification within. The point, my lord, is
It's
that
20. It's paragraph 21.
yeah,
page
my lord,
37.
that's the point.
Thank you.
My lords, if I shall move on to the position of Mr. Bell, unless your lordships have any further questions as to the position of Mr. Frenkel.
Yes.
In respect of Mr. Bell, in the first judgment, there was a finding that he was confused by events in 2010. And this is provided at paragraph 34 of that judgment, which is in the supplemental behind tab 14, page 151. So this that conclusion at paragraph 34 is part of his lordship's analysis of the evidence given to him and his findings as to that evidence. The relevant passage starts at paragraph 27, where he records that there were inconsistencies, such as to cause him to be cautious about accepting the contentious evidence of any of the main witnesses, including Mr. Bell, at face value, particularly when not corroborated or supported by contemporaneous documentation. And then it goes on to paragraph 28 to deal with the position of Mr. Bell. My Lords, as part of trial 1, there was substantial cross-examination of Mr. Bell as to what has been described as to his subsequent conduct, as impacting upon what he understood the position to be as at 2010. And in particular, in light of what's been called the Frenkel disavowal. And my Lord, you'll see between paragraphs 28 through to 33, his Lordship provides his views as to that evidence and recording what was said. My Lords, I do particularly point out paragraph 30, in the second sentence of that paragraph, whereby Mr. Bell agreed that when it was put to him that he was then dealing with Mr. Liampert on behalf of Inc., that these were in effect interchangeable. The evidence of Mr. Bell is that certainly from 2010 onwards, he did see Inc. and Liampert as being interchangeable. And that is a point that is also repeated by the judge in the second judgment, paragraph 70, which I'll take your Lordships to shortly. But the point, my Lords, is when one looks at paragraph 34, there is a finding there as to the state of mind of Mr. Bell at the point of the Frenkel disavowal, as a consequence of the Frenkel disavowal, which is one of confusion as to what was the effect of, if any, the Frenkel disavowal. And it picks up certain themes which carry through into the second judgment, such as the fact that Mr. Bell did not have a sophisticated grasp of what would be called corporate structures, which again, as I said at the opening, is not a criticism of Mr. Bell, it's just the reality that he's just a businessman doing his business. In circumstances where he was then, at this point, I've gone to show you your Lordships, anticipating further business between Inc. and UK, and that he considered Inc. essentially to be interchangeable with Mr. Liampert and vice versa. My Lords, just in respect to the Tipples judgment, I should take your Lordships to paragraph 121D of that judgment, which include the findings of Mrs. Justice Tipples, which is located at page 82 behind tab 10. And in particular, paragraph 121D records her findings as to what was agreed in 2004. That's the final sentence. Rather, the agreement made between Mr. Liampert on behalf of Inc. and Mr. Bell was that Inc. would own 51% of the UK share capital. I now propose to move on to the events in 2010, where we have, to begin with, the Frenkel disavowal. My Lords, that's described in brief terms within the second judgment, judgment below on appeal, paragraphs 3 and 4, which in the core bundle is page 197. There were two conversations between Mr. Frenkel and Mr. Bell. The first in February, and then the second in March. They were that he, Mr. Frenkel, was dissolving Inc. and wanting nothing more to do with UK, and the business was his to do with what he liked, And then in the March, he repeated that position and told Mr. Bell the company was his. The effect of the Frenkel disavowal is that, as recorded in the final sentence, he was making clear that he, i.e. Frenkel, was walking away from UK. Between those two conversations, there was also a conversation between Mr. Liampert and Mr. Bell. This is recorded in paragraph 36 of the judgment under appeal, at page 209, beginning the next day. So this is after the February conversation. The next day, Mr. Liampert phoned Mr. Bell to tell him that Mr. Frenkel had closed down Inc. and taken its staff to a new company. My lords, ask you to pay...
Sorry, which paragraph are you in?
36, page 209, at the bottom, my lords.
Oh, yes.
Mr. Liampert assured Mr. Bell that he would carry on with Inc. as best he could. So there is a statement from Mr. Liampert that Inc. isn't essentially going anywhere, that Inc. is still going to be around, and that he would carry on with that. My lords, again, that goes into this issue, which I'll come on to, as to what was the meaning of the disavowal, and what was Mr. Bell in particular's understanding. Was it that Mr. Frenkel was simply walking off over the hillside, or was it Inc. giving up its beneficial interest in UK? My lords, that conversation is set out in more detail within the Tipples judgment at paragraph 100, which is within the supplemental bundle at page 76. So paragraph 77 details the first conversation between Frenkel and Bell. And then paragraph 100 then deals with the conversation that then took place between Bell and Mr. Liampert. And as you'll see, my lords, what Mr. Bell was effectively seeking was reassurance from Mr. Liampert that arrangements with Inc. would continue. And with Mr. Liampert saying to Mr. Bell that he would carry on with Inc. and that the intention was for Inc. to continue trading with the UK, and vice versa. My lords, there was then what's been described as the 2010 agreement.
Sorry, is it your submission that the telephone conversation referred to in the judgment under appeal at paragraph 36, the next day Mr. Liampert phoned Mr. Bell, etc., is the same conversation as referred to in paragraph 100?
My lord, it would appear there are inconsistencies between the two, but they would fit with what is understood to have taken place, the conversations, which then led up to the 2010 agreement arrangements.
Because they seem to me to be different. They're described differently.
Well, my lord, they may well be. That's not a point that's being resolved. But the submission I make is that the substance of them, even if there were two conversations, was the same.
Do we not need to be a bit careful? Your client wasn't party to the 2015 proceedings, but is party to these proceedings. These proceedings contain findings of fact by the judge in two trials. Then we have to work out, regardless of what Ms. Tipples may or may not have found, then we have to work out what findings of fact the judge made in these proceedings and what the legal effect of those is, and whether those findings of fact are sustainable or can be overturned. So it's all very interesting to see what Ms. Tipples decided, but if it's inconsistent, we're not actually...
I fully accept that, my lord. I do fully accept that. The difficulty is that the judgment is not perhaps potentially as detailed as it could have been, and it's a question of trying to understand for your lordship, explain to your lordship what is the understanding of what took place. Now, to the extent to which, my lords, there is a distinction or difference between what's said in Miss Tipple's judgment and what's said under the judgment and appeal, I fully accept that your lordships will clearly have to be very careful about assuming that, making certain assumptions. I fully accept that, my lord. What I'm trying to do is explain to your lordships what has gone on in what is a complicated position in which there's been now 3 trials within this jurisdiction in respect of what one could call the matter. So I do fully accept your lordships and recognise your lordships' concerns in that respect.
In the proceedings in our case, the one we're hearing an appeal in, although there were 2 hearings before Mr. Honour Judge Jarman, as I understand it, there was only evidence called at the first one, and the second one was just submissions.
It was. That's correct, my lord. Yes. But one of the difficulties is that, or one of the, it is a difficulty, is that when the judgment under appeal is looked at, one can see that what the judge is doing is looking back to see what has been said previously and recorded as having been said previously by the witnesses.
Well, yes, but we have to read, do we not, his first judgment and his second judgment to work out what his factual findings are, and those are the factual findings we have to work with.
Yes, my lord, I fully accept that.
Yes.
I do. I'm simply just trying to...
Yes.
It is a complicated position. My lords, we then go to the 2010 agreement arrangement. And again, I don't think this is controversial as to what the effect of that actual conversation was between Mr. Liampert and Mr. Bell. In that respect, it is that preferential trading came to an end, the profit shares came to an end, and that they would then be trading as per usual and trading with each other. My lords, I was going to take your lordship to paragraph 106 of the Tipples judgment that records what took place as a finding of fact within the Tipples judgment, which of course does bind Mr. Bell. But again, I fully recognise your lordships might be reticent to look at that, but it does provide what I think is going to be uncontroversial evidence as to what that conversation was. And none of this is inconsistent with each other. The point, my lord, is that whatever Mr. Bell's state of mind was, there is evidence as recorded within the first and second judgments that he was confused as to the effect of what had happened, that he understood that he was carrying on trading with Inc., that he was carrying on dealing with Mr. Liampert, and that Liampert and Inc. were interchangeable with each other. And in respect to that confusion, in the first judgment, his lordship did deal with the issue of Mr. Bell's state of mind as a result of the events in 2010, identifying that there was confusion on his part. My lords, in particular, in doing so, he considered and placed reliance on what's been called the subsequent events. That's, my lords, what is said at the paragraph 34, page 151 of that first judgment, where his lordship has analysed the evidence of, it's the passage I took your lordship to earlier, but for completeness, page 149 through to 151. And that, of course, is a passage which goes directly to, we say, the question of reliance, ultimately. Further, that passage in respect of the confused state of Mr. Bell's mind and the reasons why the judge considered that there was confusion are mirrored by how his lordship dealt with the issue of contractual surrender. In respect to the issue of contractual surrender, one issue which arose was whether there had been discussions, actual discussions between Mr. Bell and Mr. Liampert as to ownership of UK. As to that question, which is a question of fact, were there any discussions, such as to give rise, say, to an express term? We submit that his lordship found as a fact that there was no such discussions.
I don't think that's in dispute, is it?
I appreciate that my learned friend nodded to agree, I think.
Shook my head to agree.
Right, thank you. But for completeness, the only point, my lord, is that on paragraph 45, it says, however, these inconsistencies cause me to doubt. But then over at paragraph 48, 213, towards the bottom, his lordship is proceeding on the basis that there were no discussions. It was just in case there was some suggestion, well, actually, there's not a finding of fact that there weren't any discussions. We submit that it is a finding of fact that there were no such discussions, and I'm grateful to my learned friend for confirming that. But in reaching that conclusion, my lords, what his lordship did to assist him in determining that question of fact as of early 2010 was to look at the subsequent conduct, i.e. the events following the Frenkel disavowal, as being relevant and of assistance to his lordship for determining that issue. And he does that in paragraphs 41 onwards. In paragraph 40, there is the issue of the subsequent conduct that Mr. Barden will address your lordships on in more detail. But we have the solicitor's letters, which I've taken your lordships to. Paragraph 41 is dealing with Mr. Liampert, and I will come back to that because that's relevant, because his lordship, despite saying that Mr. Liampert always thought that nothing had changed in 2010, then finds that Mr. Liampert did place reliance, as a matter of fact, on the assurance given on behalf of Inc. But there is discussion at 40, 42, 43, the issue of the deposition within the Californian proceedings in 2012, the issue of what was said within 2015, and also the letter that your lordship saw earlier, paragraph 44. And what his lordship does in paragraph 45 is to say, well, in light of those inconsistencies, I don't accept that there was a conversation in 2010. So to support that finding of fact, his lordship has, we say, expressly relied upon the subsequent conduct as being clearly highly relevant. And my lord, we say that that was correct of his lordship to do so, specifically in light of his earlier paragraph 16 of this judgment, which is located at page 202, where he sets out the basis upon which he's going to deal with issues of fact. Where he does identify that there are substantial credibility or reliability issues as to the evidence, each of which of them with little or no independent corroboration. So having
Which is the passage of the first judgment in which he makes the substantial credibility issue as to Mr. Bell.
Is it paragraph 45, page 153 in the supplement?
Yes, my lord. That's at page 153.
Yes, well, I was
And there's
wondering what the... I mean, the nature of the problem that the judge had with Mr. Bell's evidence was that it was unreliable because of confusion rather than that it was untruthful. Is that right?
Yes, my lord, that's correct. So we did submit that it was, when properly looked at, untruthful, but his lordship found that it was not untruthful, it was confused.
Yeah, all right. Well, that's obviously for any witness, that's quite an important distinction.
Yeah. But my lord, the point of that confusion essentially explained the various positions that Mr. Bell appeared to take subsequently. But the point, my lord, the critical point is what his lordship did was to say, well, that subsequent conduct shows that as of 2010, Mr. Bell was highly confused. It showed, quote, show a high degree of confusion in his own mind as to the legal position relating to ownership and profit distribution of UK and the control of Inc. after his conversation with Mr. Frenkel in 2010. That's Judgment 1, paragraph 34.
Well, that's slightly odd, isn't it? I mean, you could see that if there was a finding of untruthfulness, that might lead down one route, but it's not so obvious that what you say is unequivocal conduct later indicates confusion earlier.
Forgive me, my lord, could you just repeat that so I can understand?
Yes, it's not obvious that... I mean, your case is that what you call the subsequent conduct is clear and unequivocal, that Inc. are still owners. And it's not obvious, if you're right about that, and right to characterise the subsequent conduct in that way, that indicates confusion in 2010
No, I fully accept that.
as to the effect.
But the difficulty
if there'd been a finding that he'd been untruthful about something, that might be different, but he hasn't done that.
No, I fully accept that. But the point, my lord, is that the way that the judge has dealt with this issue of contractual surrender in particular is that in answering the question as to what took place in the spring of 2010, he has placed very clear reliance upon the subsequent conduct in rejecting any suggestion that was an express discussion as to ownership. And he's also gone on to find that there was confusion on the part of Mr. Bell in respect of matters, not just subsequently, but as of 2010. And then the difficulty is that when you get to the issue of reliance, where it is a matter of fact that has to be established that Mr. Bell did rely upon, to his detriment, the assurance that Inc. was walking away from its interest, in the respect of that analysis, his lordship then says, well, the subsequent conduct doesn't assist, because essentially it only goes to the matters of fact post-2010, i.e. 1 or 2 years later, i.e. at the time of the subsequent conduct. So that's the fundamental inconsistency within this judgment, because you have his lordship dealing with one point of fact on a certain basis, utilising certain evidence and findings that he has, to then essentially discount that same argument on another question of fact as to proprietary estoppel and the reliance that was placed by Mr. Bell on the assurance given. And my lords, that's the fundamental difficulty with this judgment on proprietary estoppel. That finding is not consistent with the remainder of the judgment, and is also not consistent with the first judgment, where his lordship, at paragraph 34, says that Mr. Bell was confused as to what, if anything, had happened in respect of ownership as a result of 2010. And again, in reaching that conclusion, he's also relied upon the subsequent conduct. And yet when we get to the analysis of reliance, paragraph 69 through to 75 of the second judgment, that's essentially all just washed away. It's saying, well, it's not relevant because it happens several years later. It doesn't affect. I find, therefore, that there was actual reliance. Apparently, to the extent that Mr. Bell thought and knew and understood that Inc. was giving up its interest. I mean, there are problems with that analysis in itself, but this is a fundamental inconsistency which we say exists within this judgment.
We'll come to it, but when we come to reliance, the judge's factual finding, as I understand it, is he accepts as true evidence that Mr. Bell gave him, that if he'd understood that he could still be in a relationship with two warring parties, he would have closed down UK and set up a separate business. That's the fundamental finding of fact. Now, is that inconsistent with the conclusion earlier that he didn't really understand the ownership structure of Inc. and didn't really understand the difference between Inc. and Frenkel and Lampert, and he didn't really think about the legalities. But what he was, on the judge's finding, clear about was if he was still going to be stuck in a relationship with those two who had fallen out, he wouldn't have continued with it.
The slight tweak, my lord, is that it's not so much that he was still going to be in a relationship with those two. He was happy to still be in a relationship with Mr. Lampert.
Yes, he did not want. He didn't want to be in any sort of relationship with Frenkel, but Frenkel remained an owner. Mr. Frenkel remained an owner of Inc. So that if Inc. was in fact involved in the business still, he would still be involved in a relationship with Mr. Frenkel.
I think, my lord, that goes potentially to the real issue here, is that what was being said and what was being understood by Mr. Bell was not that Inc. was giving up its interest so that Inc. had disappeared over the hillside. It was that Frenkel had disappeared over the hillside, which is a materially different point. So for the proprietary estoppel, the assurance relating to the property is Inc.'s beneficial interest.
But the only way in which Mr. Frenkel could walk away from the companies, given that he remained an owner of Inc., was for him to effectively say, I'm not going through Inc. to have any further interest in the company. And therefore, he was giving up Inc.'s interest in the company because that was his interest in the company. He didn't have a direct ownership interest in the company. It was all through Inc.
My lord, I think it's accepted, I might be told that this is incorrect, but I think it's accepted that what must be shown for this proprietary estoppel to successfully operate on Mr. Bell's case is that he must show that he placed a reliance on a representation or assurance given to him in respect of specific property, that property being the beneficial interest of Inc. in UK. His reliance, if any, was not on that. Rather, it was on the fact that Mr. Frenkel had said he's disappearing over the hillside and gone, which is not the same thing at all. And that's consistent with the fact that then Mr. Bell was very happy to carry on dealing with Mr. Lampert and Inc. That relationship continued, which is what he wanted, what he needed. So his reliance, if anything, is on a different point. His reliance is on Frenkel telling him, I'm off, I'm gone, which of course isn't going to work for the proprietary estoppel claim that is being brought.
Okay. Well, I see the way in which you put it. Yep.
So, my lords, what we do say is that there is that inconsistency of the treatment of in the judgment as to these questions of fact, comparing how the issue of contractual surrender has been dealt with in Judgment 2, also how the judge approached questions of fact in Judgment 1, and then his findings in respect of Judgment 2 as to proprietary estoppel. My lords, it might be useful to go to the issue of proprietary estoppel and reliance under paragraph 69 onwards. This is within the core bundle, paragraph 9. We do say that with respect to the to learned judge that this is in itself essentially a confused analysis. So what you start at paragraph 69 with is a statement which your lordship was debating with me earlier, that there was a clear enough assurance that Mr. Bell and Mr. Frenkel wanted nothing to do with UK, and that the company business was his to do with what he liked. And then, so that of course is not sufficient, we say, for the proprietary estoppel. And that of course explains why we end up with the final sentence in paragraph 69. But before we get to that final sentence, what the judge does, which is correct, is to identify that Mr. Bell did not want to be between the two warring parties, Mr. Frenkel and Mr. Liampert. And that he thought, as a result of the disavowal, that concern disappears. His lordship then records, obviously, Mr. Bell's general lack of understanding as to the precise legal consequences. And then what mattered to Mr. Bell was that Mr. Frenkel, one of the warring factions, was out of the picture so far as UK was concerned, and that Mr. Bell was free to deal only with Mr. Liampert, with whom he remained on friendly terms. That paragraph up to that point would not satisfy, we say, a reliance claim in respect of Inc.'s beneficial interest in UK. It doesn't touch upon that point.
Well, the first sentence says the company is his to do what he liked with. That's effectively saying it's yours. And that is the finding of fact, isn't it? It's your company. That's Mr. Bell's company. You can do what you want with it.
But my lord, the difficulty is in respect to what does Mr. Bell understand this to be? Well, but he understands that Inc. has not gone anywhere. So the point is, it's Mr. Frenkel saying you can do what you want. It's your company. But in circumstances where you then have the following analysis, which is that Inc. is still involved in that relationship, that arrangement.
Because Mr. Bell is happy to continue to deal with Mr. Liampert. Mr. Liampert tells him, don't worry, I'll carry on with Inc. as best I can. And Mr. Bell thinks, the judge finds, that Liampert and Inc., that's the same. So the first sentence of that paragraph is a finding of what Mr. Frenkel assured Mr. Bell.
Yes.
And the final sentence is a judge's finding as to what he's likely to have understood by that, which is that it is his company in the sense that Inc. is, that's Mr. Frenkel, he's giving up Inc.'s interest in the company. The fact that he then is free to deal with Mr. Liampert and he doesn't really understand the difference between Mr. Liampert and Inc. It's not inconsistent with those two findings, is it?
I submit it is. There is an inconsistency because it takes the Frenkel disavowal and interprets it in a specific way to make, therefore, a finding of fact as to reliance. And it's that jump in logic that we say doesn't work.
If the substance of what Mr. Frenkel is saying is that he is going to disappear from the picture, disappear over the hill, as you put it, then given that he is a shareholder of Inc., there are only two ways on there in which that could happen. One is that he is going to relinquish his shares in Inc., and the other is that Inc. is going to relinquish its interest in UK, so that Mr. Bell can then deal exclusively with Mr. Liampert.
Yes, my lord. But the difficulty is that where you have the representation, in order for the claim to work against my client's beneficial interest, is that there has to be an understanding on the part of Mr. Bell that the effect of the words used was that Inc. was giving up its interest, that was the route forward, and it doesn't follow at all that necessarily is the case, or the necessary implication. And my lord, the difficulty is that there has to be a finding of fact that was Mr. Bell's actual understanding.
Well, that's why I say if you look at the first sentence, the judge interprets what he finds Mr. Frenkel has said as including a statement that the company is yours. That's Mr. Bell's. It's implicit in that the interest which collectively the Americans had in the company is being given up because there's no other way in which the company can be Mr. Bell's. I mean, that is what the judge finds the statement to have been. And then in the final sentence, having said that's important to him, because the last thing he wanted was to be stuck in years of dispute between Mr. Frenkel and Mr. Lampert, which is, of course, what's actually happened to him, he finds in the last sentence a reasonable understanding by Mr. Bell that he could treat it as his and so deal with Mr. Lampert in any way he wanted. And I don't find that difficult to understand as factual findings or as inconsistent with any amount of either then or subsequent confusion as to quite how it worked.
But I think, my lord, the difficulty is that assuming that that is the correct way to view the finding of fact on this point, that is then still not consistent with how his lordship has then dealt with the subsequent conduct, because the subsequent conduct is identified to make findings as to a confused state of mind on the part of Mr. Bell. So that's where you would have this tension between a finding that Mr. Bell understood that Inc. was giving up its interest in circumstances where the subsequent conduct has been relevant.
Yeah, but I think that's a separate point.
Yeah,
Your point you were addressing us on was that down to the last sentence of paragraph 69, it doesn't say anything about Inc.'s interest. And what I'm putting to you is that actually the first sentence does implicitly say something about Inc.'s interest, because by saying the company is yours, he's giving up any interest which he personally or Inc. has in the company. And that the final sentence says that's how it's understood. And it's reasonable to understand it that way. Now, those are factual findings. As I say, I don't myself think those are internally inconsistent. You want to say they're inconsistent with the way he dealt with the contractual surrender point, but I think that is a separate point. That's a question of what use can you make of subsequent conduct.
I think the point I'm trying to make is that the way that his lordship has dealt with this whole section is in our submissions unsatisfactory. That there are inconsistencies. There's no logical process being played out here in respect of determination of this issue of reliance. My lord, if we can move on to paragraph 70, what his lordship is then doing is identifying and confirming previous findings as to the fact that Mr. Bell is not particularly concerned with the issues of corporate identity and that he saw Inc. and Lampert as being interchangeable. And those are points which also go to what Mr. Bell understood. And my lord, that's the point as to whether Mr. Bell understood that Inc. was giving up its interest. And then over the page, my lord, paragraph 71, he deals with this issue of the subsequent conduct by identifying the fact that it was obviously put to him that, well, actually, all the subsequent conduct doesn't support a finding that Mr. Bell did believe that there was a surrender of Inc.'s interest, or giving up of Inc.'s interest. He identifies those arguments in 71 in short form, which is fine. But then at 72, he identifies an issue of timing, which is correct. Paragraph 73 deals with the issue of the evidence given by Mr. Bell. And that goes to the point of the conflicting evidence that was given by Bell. And then he concludes, he records at 74, again, the arguments and submissions made to him, and at 75, then goes on to proceed on the basis that, and this is the actual finding of reliance, he deals with it by saying, in respect to the subsequent conduct, essentially the confusion that arose on the part of Mr. Bell only arose subsequently. So, i.e., a year or two later, after 2010. So the way that he answers the issue of the subsequent conduct is by saying, well, the subsequent conduct occurred 2012, 2015. By that point, Mr. Bell was confused. And therefore, he wasn't confused as in 2010. That's the way we understand paragraph 75 has been drafted.
Now, can we just see where we are on this, on your submission? The judge has made a finding of reliance, which, on the face of it, you have to say he wasn't entitled to make, because if he was entitled to make it, it's a finding of reliance, and it gives rise to proprietary estoppel. You say he wasn't entitled to make it because of the subsequent conduct, so that simply wasn't open to him on a fair view of the evidence as a whole. But the judge, in deciding whether to make that finding, has, as it were, confronted, you may say unsatisfactorily, but he has confronted the subsequent conduct and said that, in his view, that doesn't prevent him from making the finding. Now, is that the right analysis of these paragraphs?
I don't think so, my lord. I think the point being is that there's an inconsistency in how the judge has dealt with two issues of fact. The first issue of fact is as to what, if anything, was said in 2010 in respect of ownership, as a matter of fact. In deciding that nothing was said, he's placed reliance upon the subsequent conduct to find that there was no discussions. So he has accepted and used the subsequent conduct to make a finding of fact as to what was or was not discussed in 2010.
And it's inherent in that, you say, that the subsequent conduct is relevant to what took place in 2010, whereas here he's saying it's irrelevant, and you say you can't have it both ways.
Very simply.
Rather, the judge can't have it both ways.
Yeah.
It's either relevant to 2010 or it's irrelevant to 2010.
Right, my lord.
I think the point that's taken against you by Mr. Trigger is that when he's dealing with whether there were expressed discussions, what he's effectively saying is that if there'd been an expressed discussion as to how it was to be owned, then you wouldn't have had the subsequent conduct because there wouldn't have been the confusion. Now, is that inconsistent with saying, actually, he didn't understand quite what had happened in 2010. He was confused, but the one thing he was clear about is that if he had thought that the company wasn't his to do what he wanted with, he would have walked away from it. I understand the way you put it. You say he's using it in one place and then saying you can't use it in another place. But is there really an inconsistency?
We say there is an inconsistency there. Because what he's doing initially, he's saying, because of the fact there was subsequent confusion, there weren't any discussions earlier in 2010. When here he's saying Mr. Bell understood and relied upon that there was an actual change of ownership at the time, and that the subsequent conduct, the confusion, only arose later. My lord, paragraph 76, second line down, and in this jurisdiction became highly confused.
Yes.
That's for example, the use of the word became is so there is a fundamental inconsistency between the two. And then, of course, you have on top of that the first judgment, where you have his lordship saying that as at this point, Mr. Bell was confused. Paragraph 34. Well, unless there's anything else on that particular ground, I was proposing to move on to the issue of unconscionability, which I can deal with very briefly.
Yes.
My lords, in respect to this, we don't understand that there's a dispute between the parties, that it must be held that it would be unconscionable for Inc. to resolve from the assurance given, and which has been detrimentally relied upon. And we also don't dispute that the issue of unconscionability is not a separate issue. What we say is that it's essentially a sense check, as per in COB, page 1788G. But the point of this ground is simply to identify that if one looks at the judgment and how the judge dealt with the issue of laches and proprietary estoppel, they are in themselves, we say, inconsistent. My Lord, if you look at paragraph 77 of the judgment, page 221, the point of detrimental reliance and therefore unconscionability is halfway through that paragraph, based upon the subsequent events in respect of UK becoming a substantial success. So his lordship has dealt with the issue of unconscionability by reference to the future growth of UK, and has held in those circumstances that it's unconscionable for Inc. to resile from the assurance given. And it's a short point, but when one then looks at the issue of laches and how his lordship has dealt with that, which starts over the page at 223, and the judgment relevant paragraphs at paragraphs 83 to 86 at page 223, what his lordship is also doing in that respect is saying, well, actually, Inc. cannot be blamed for what has happened and for not coming forward because of the conduct of Bell and UK subsequently. You have the issue of the deadlock, which isn't to do with Bell and UK, but then you have 84 and 85. There's criticisms of Bell and UK for them not making their position clearer, and then obviously in 2015 and the 2016 letter and the judgment 2017 positively asserting that it was Inc. who was the beneficial owner of UK. And when we say that that is illustrative of the inconsistency within the judgment on the issue of unconscionability, he's looking forward and saying it's unconscionable for Inc. to assert a right, and yet it was apparently fine for Inc. to delay and to assert a right later on. My Lords, unless there's any questions on that point, I was going to move on to deal with implied terms, which I believe I can deal with quite quickly.
Yes, very good.
My Lords, as you'll appreciate, the issue of the implied term underpins Bell and UK's case on contractual surrender, because it's the implied term which creates a specifically forcible obligation, which is then said to give rise to the constructive trust. His Lordship, in the second judgment, paragraph 48, held that it was a necessarily implication of the 2010 agreement that there was such a term, and the final sentence he describes it as being the proper inference. Page 213. Our submission is that that was wrong as a matter of law. In respect of the law, I don't believe that there's any difference between the parties. There is this issue of whether it's an implied term or a question of interpretation. Our view is that it is just simply a question of implied term.
Well, that's what the judge says in the first sentence of 48. He says it's a necessary implication.
Quite, my Lord. So I'm just going to address it on the basis it's an implied term. And as I'm sure your Lordships, I know your Lordships are fully aware, the question is not whether it's reasonable to imply such a term. The question is whether it's necessary to give the contract business efficacy, or it would be so obvious, quote, it goes without saying, close quote. We do say that the events in 2004 are relevant. We don't say they determine matters, but they are relevant. And we say that on the basis that when one looks at the arrangement entered into in 2004, as his lordship found, the three elements were divisible. Paragraph 26. He also went on to hold that there was no requirement for an implied term.
Sorry, where is that finding?
That's forgive me. No requirement for an express. No requirement for an implied term. There goes my lord. That was the section I took your lordship to. At 34. And it's the point that.
Sorry, 34 of which judgment?
The second judgment, page 219.
Oh yes, thank you. Yes, you did take us to that.
And these are points essentially I've already made, my lords. But the point is,
so just to be clear, as far as that point is concerned, do I take it that your submission is that the judge was right to say that there's no necessity to imply such a term in 2004, and you say logically the position would be the same in 2010? Is that the submission?
yes, my lord. But it also goes to the point further. The general point of commerce is that it doesn't have to follow, or shouldn't follow, that because one enters into an agreement so that there's an entitlement to a profit, that must also be accompanied by an entitlement to ownership. One can have different arrangements. That is not to say that it might not be usual for the ownership to be accompanied by an entitlement to a profit, but under the test it is not necessary for business efficacy, and it does not go without saying. So therefore, on that basis, that there is no, the legal test for the implication of a term isn't satisfied. I think it's a relatively straightforward and simple point, my lords. My lords, if we can just take instructions if there's any further submissions.
Yes.
Unless you can assist further, my lords.
All right. Thank you very much. So we hear next from Mr. Barton, do we?
My lords, as you know, I appear for Mr. Frenkel, as I did before Deputy Judge Tipples, as she then was, and at the subsequent hearings in that matter and this one. I'm going to take a brief moment, if I may, to explain Mr. Frenkel's particular position in this litigation, as opposed to that of Inc., and then to deal a little, as Mr. Buck has trailed, with what's called the subsequent conduct, of which my client was, for the most part, on the direct receiving end, and then briefly to deal with the judge's approach in the light of that subsequent conduct. Now, Mr. Frenkel's position is that he was made a direct party to these proceedings by the claim of Mr. Bell and LAUK. He didn't ask to be here. He was, of course, the claimant in the original claim, as determined by Deputy Judge Tipples, in which he claimed a direct beneficial entitlement of 25.5%, i.e. half of the interest on the US side. That claim was dismissed, as my lords have seen, by the Deputy Judge, in part on the basis that she was being told by Mr. Bell that it was LA Inc. which was agreed to be the shareholder on the US side, and not two individuals. And importantly, they were telling her repeatedly through those proceedings that that remained the case as at the date of the hearing before her in 2017. It follows that Mr. Frenkel is somewhat bemused by the course of this second set of proceedings, in which the court below has been invited to and has concluded exactly the opposite of what the Deputy Judge was told in his claim, namely that LA Inc. ceased to be the shareholder in 2010, and that everything Mr. Bell told Ms. Tipples was in fact wrong. He's also bemused by one other thing, which is the effect of the judgment below and contended to be upheld, namely the extrapolation from a finding of a disavowal by Mr. Frenkel of his own involvement to a conclusion that LA Inc.'s interest was forsworn, and, in my submission even more curiously, that as a result Mr. Lyampert personally owns a 50% shareholding in the English company. And that, in my submission, is a fundamental oddity of the position advanced by Mr. Bell and UK, because it's very hard to see why, on any view, a proprietary estoppel should lead to those shares ending up in the hands of Mr. Lyampert personally. Now, Mr. Frenkel's interest extends beyond that, in that he has an ultimate interest in the realisation of the assets of Inc. in the United States. His interest is 50% once other creditors, including, for example, the taxman, have been paid. And in particular, he has an interest in the approximately $4 million that Mr. Lyampert owes to Inc. as a judgment debt, which remains unpaid. The relevance of that to these proceedings is that the stated purpose of Mr. Bell in commencing them was to establish Mr. Lyampert's legal and beneficial ownership of the one share, so that that can be sold to Mr. Bell under the so-called Santa Monica Agreement. My lords will get this from paragraph 31 of the particulars of claim, which is behind tab 12 of the core bundle at page 230. Your lordships will see there the reference to the Santa Monica Agreement.
Sorry, I must be on the wrong page. Could
Yes,
the reference?
you are, but that's because I've given you the wrong reference. Sorry, my lord.
Page 240, I think.
Yes, my lord. That's quite right. So you'll see there that what was said was that LA UK had agreed with Mr. Lyampert to purchase the one share from him for some 1.9 million. And that was said to be the reason why this claim was now brought. Mr. Frenkel's belief is that the value of that one share is something like 4 times the 1.9 million for which it's proposed to be sold. And expert evidence was tendered in the US proceedings to that effect. And it follows that Mr. Frenkel's belief is that the one share owned by Inc. ought to be sold in an open process to the highest bidder, and not in a deal between Mr. Lyampert and Mr. Bell. So that, in essence, is the relevance to my client.
You are a judgment creditor of Mr. Lyampert in California.
That's right, my lord.
You have taken proceedings in California to restrain the sale of Mr. Lampert's share, the share registered in Mr. Lampert's name.
That's right, my lord.
That injunction still stands.
I think that's right, my lord. I would have to take instructions on that. But
So why does it matter to you who wins this litigation? In the sense that either the Mr. Lampert's share belongs to him, in which case you use the execution procedures in California to make sure it's sold for a proper value so your judgment debt is paid, or it belongs to Inc., in which case, after paying the taxman and everybody else, you get a 50% share of it. Why does it matter to you what the outcome of this litigation is?
well, ultimately, it's about the process by which it's sold. As your lordship rightly indicates, there is presently an injunction in California. It's not obvious to me, at least, that that injunction would stand. It depends, I think, on the view the Californian court takes of the outcome in these proceedings.
either way, you, Mr. Frenkel, don't end up with any direct interest in the company.
No, not a direct interest, but an indirect interest. And we say that this is and always was Inc.'s share, and it ought to be sold.
I understand you say that. I understand you say that, but I've just looked at your defence, and the whole point of your defence is you don't understand why you've been brought into this litigation. It's a matter for Inc. whether it's Inc.'s share. It's not a matter for you, and you won't advance any positive case. So I'm just wondering why you're arguing anything on the appeal. Why don't you just let Inc. argue it?
There are two reasons for that, my lord. First of all, there are the points that I've just made about Mr. Frenkel's prior involvement in these proceedings and the previous proceedings, and you will understand that he feels strongly about what seem on the face of it to him to be entirely inconsistent outcomes brought about by Mr. Bell running opposite cases in two different claims. The second reason is that not only was Mr. Frenkel brought into these proceedings, but costs orders were sought and obtained against him.
Okay.
And he obviously has an interest in reversing those.
Yes.
Can I just ask you about the two opposite cases point? So I understand certainly the rhetorical force of that, but is your submission that that has any specific legal relevance? Specifically, what I've got in mind is that there is a well-known doctrine that you can't approbate and reprobate, but that never seems to have been invoked by your client, or indeed by Inc.
Issues were taken about abuse of process in the first appeal before the Court of Appeal, and so that issue is not before your lordships again.
Right.
Where it is, I would say, of very considerable relevance on this appeal is as an evidential question. It is the essence of my submissions is going to be that it was not the judge, having taken the approach that Mr. Bell was an unreliable witness in terms of his recollection. It was not open, and therefore that he should look at the documents and the inherent probabilities rather than what any of the individual witnesses were saying to him they thought in 2010. It was not open to the judge looking at the documents which show the subsequent conduct and show the directness and the vehemence with which Mr. Bell took the position that Inc.'s interest had not been lost in 2010. It was not open to the judge, in my submission, to conclude that Mr. Bell, on the balance of probabilities in 2010, held completely the opposite belief from that which he was advancing in courts from 2012 through to 2017. As a matter of inherent probabilities, my submission is that that simply doesn't work. And that is, coming back to my Lord Justice Arnold's conceptual point, that is a reason why, even if the doctrine of abuse of process may be relatively narrow, in practice, one rarely sees people before the courts getting away with approbating and reprobating, because the court is well entitled, as a matter of evidence, to take account of the fact that they were saying exactly the opposite, only quite recently and in very clear terms. So that's going to be the essence of my submission as to why it wasn't open to his lordship to find as he did. And I do, for the avoidance of doubt, adopt Mr. Buck's submissions that there is also an inconsistency there, because his lordship didn't follow that same, I say, illogical approach in relation to the question of whether there was agreement between Mr. Bell and Mr. Lyampert. He, in my submission, rightly couldn't bring himself to envisage a situation where they had sat down and thought that what had happened was that Inc.'s interest had been lost and they were agreeing to reallocate. But in my submission, the same logic must apply to the question of what Mr. Bell subjectively thought in 2010. Just in terms of what reliance requires, I deal with this at paragraph 28 of my skeleton, and I cite one case and a couple of textbook authorities. I'm not sure that there's a need to take your lordships to those, certainly for now. As I read paragraph 28 of Mr. Twigger's skeleton, it seems like we are on the same page here, namely that Mr. Bell and LAUK appear to accept that what was needed for reliance was a finding that Mr. Bell did understand that LA Inc.'s interest had been abandoned. And as I read paragraph 28 of Mr. Twigger's skeleton, what they seem to be saying is that there was an implicit finding to that effect. So on that basis, that is what Mr. Bell would need to show. Turning then to what's being called the Frenkel disavowal. In my respectful submission, that is a set of words which could be taken to mean at least three different things, and the three I identify are as follows. One is, as put by my Lord Justice Nugee, that Mr. Frenkel is unilaterally terminating or abandoning Inc.'s interest in LAUK. A second, which he also contemplated, is that Mr. Frenkel is abandoning any interest of his in Inc. That would also achieve the stated position of Mr. Frenkel not having anything to do with LAUK. The third possible interpretation of that statement is that it is legally meaningless. That it is something which is said in peak, and that it turns out on analysis not to be so simple to abandon an interest which is held by a company, LA Inc., of which you, Mr. Frenkel, are but a 50% shareholder and one of two directors. And someone hearing that statement could interpret it in any of those three ways. It's possible to understand it in any of those three ways. The only way in my submission that Mr. Bell could win is that if he had been able to show that he did actually understand and rely on the statement in sense A, first one, and not in sense B or C. He has to have believed in 2010 that Inc. was gone, it was no longer a co-owner. And the fundamental point is that all of the subsequent conduct is fundamentally inconsistent with that state of affairs. It's very clear that throughout he asserts that Inc. remained a co-owner after 2010. So at risk of repetition, the point will be that there is nothing in the objective documentary record which points to Mr. Bell having had in 2010 the understanding that he now says he had, and which the judge implicitly or rather unclearly appears to have found that he had. And so the question I would invite your lordships to ask themselves as I take you briefly to the salient points of the evidence are, is this evidence consistent in its totality with the view that Mr. Bell had and relied on in 2010, a clear understanding that Inc. had ceased to be an owner. And these documents are all in the supplemental bundle. So the first one is at page 1 of the supplemental bundle. So these documents are emails in 2010 at the bottom and 2011 at the top. I believe from memory there was a dispute as to whether the 2010 version was received. From Sophia Fren is the name of Mr. Frenkel's mother, that this email was written by Mr. Frenkel. You see it's signed by him. And what he's referring to here is the fact that he's been doing a reconciliation of the profits between LA UK and LA Inc. as part of their trading relationship. And he's telling Mr. Bell that will be done by Monday. Now, one might immediately ask why he's doing this in February 2011, if he has ceased to have any ownership interest a year previously. But he then also says, please review the attachments, sign and return via this email. And you see over the page the attachment, which is a declaration of Mr. Bell. And on page 3, the proposed paragraph 10, which is, I hereby state and declare that Roman Frenkel holds 25.5% of all issued and outstanding shares. Now, Mr. Bell doesn't sign that declaration, of course, but it's clear that from at least this point, so we're in February 2011 here, so about a year after the relevant events in this case, it's clear that he understands what Mr. Frenkel's position is, that Mr. Frenkel remains a co-owner. And there's no pushback on that from Mr. Bell whatsoever. To the contrary, what one then gets a year later, perhaps I should show you page 4, which is his response. He says, thank you for the figures. I've been asked by my lawyer for you to call him as he has a few questions about the document you require signing. And the upshot is the document doesn't get signed, but Mr. Frenkel calls Mr. Bell as a witness before the California court to give evidence on precisely this topic. And that's what one gets at tab 3 of the supplementary bundle, so beginning at page 18. And you see there, that was the deposition of Mr. Bell. And then on page 19...
And this was on oath?
Yes, exactly. Page 19, bottom right-hand page, line 4 and continuing. So this is against the background that he's been asked by Mr. Frenkel to give this evidence. And of course, Mr. Bell understands that that request has been made in the light of Mr. Frenkel's position, which you saw in the draft declaration. If we then go on to page 20 of the bundle, so internal page 9, you will see Mr. Bell is being questioned about the company. He's asked about the form of the company, he's asked about when it was formed, and then he's asked who are the owners of LA Micro UK, and my lords will be able to read his answer, which is given in the present tense, and we submit was the correct answer then, remains the correct answer now, and more importantly reflects his understanding given on oath. And this, to remind ourselves, is 2 years after the relevant events. The trial before His Honour Judge Jarman was 11 years after the relevant events. And so you see the answer that he gave there. And he draws, strikingly, a clear distinction between what he describes as the company's house position and the actual ownership. So whatever is said about his understanding or lack of understanding of corporate forms and beneficial interests and so on, he clearly knows that there is a difference and he's able to explain it correctly. Now,
This is evidence in litigation between Mr. Frenkel and Inc. Was the issue, or was one of the issues in that who was the owner of UK, with Mr. Frenkel saying it was him as to 25.5%, and Inc. saying that it was Inc. as to 50 or 51%?
not quite. It is litigation. Inc. is a named party, but in effect, Inc. is the subject of the litigation rather than the party.
Right.
You'll see on the front page that Mr. Ljampert is also named as a party.
Oh, yes.
And so these are, the proceedings are probably best characterised as something similar to proceedings in either unfair prejudice or a member's voluntary winding up. The dispute is essentially about what the assets are of Inc., whether Mr. Ljampert has taken money, which he was found to have done, and so on. And my lord will have seen, of course, the draft declaration, which was in those same proceedings, in which Mr. Bell was being asked to give evidence about ownership. So I can't tell you with specificity how precisely the issues were defined, but it would have been plain to Mr. Bell that it was on the agenda.
I had some evidence as to what all the Californian proceedings were when this came before me on the jurisdiction.
Yes.
And I think I set out in that judgment what all the various actions were. Have we got...
We certainly have got your judgment, my lord.
I've got it in tab 11 of the
Yes.
supplemental bundle.
So page 84 is...
Yeah, I think the relevant bit starts on page 89.
Yes, if you look at paragraph 25, I
Yeah.
think that's the same docket number, BC 434040.
Yes.
And the way I describe it there, I can't remember, but I describe it there as an action requesting dissolution and making claims for breach of fiduciary duty and the like.
Yes, and you'll see there, my lord, that two of the things which were identified were breach of fiduciary duty and conversion of corporate assets.
Yes.
And of course, one of the points that is made, both at that time and subsequently, is that Mr. Ljampert was treating the share in UK as his own and taking distributions from UK as his own, when Mr. Frenkel's position was that either those distributions should be split between them 50-50 as individual beneficial shareholders, or they should go to Inc. and be split between them in that way.
Yep.
So it's clear one way or the other that this was very much on the table when Mr. Bell was giving his evidence in the United States. It couldn't have been a surprise to him given the contents of the draft.
Is what's said at paragraph 26 of that judgment relevant for this purpose? So my lord says there that in August 2011, Mr. Frenkel applied for permission to amend the complaint in the fiduciary duty action to assert that he and Mr. Ljampert have beneficial interests in LA UK. That was denied because it was too late. But certainly that would suggest that even if it wasn't formally an issue, nevertheless it was something that was in the cognizance of the parties.
Exactly, my lord, and Mr. Frenkel has been attempting to raise this issue before the courts, and that is part of the reason why he ended up before Deputy Judge Tipples in the English court.
I mean, you say that here is Mr. Bell saying something in the US proceedings which is contrary to his position here.
Yes.
But there may be force in that. But Mr. Frenkel is also encouraging him to say something in the US proceedings which is contrary to Mr. Frenkel's present position. So there's a certain amount of pots and kettles on there. Mr. Frenkel wants Mr. Bell to say that Mr. Frenkel has a direct 25.5% interest, and that seems to be a considered position rather than forgetting the involvement of Inc. And that's contrary to what he's saying here. So I'm just wondering quite what's going on in this
there's a number of points about that, my lord. First of all, it's not contrary to what is the real issue in these proceedings now, which is not about whether the original owners were Frenkel and Lampert individually or Inc. as shareholder of the 51%. That was the issue, and that was the issue, or one of the issues that Deputy Judge Tipples determined. The issue in these proceedings is about whether the interest on the US side was terminated in 2010. And what Mr. Frenkel was inviting Mr. Bell to say here wasn't inconsistent with the case we make now in relation to that. It was consistent with it. The point was that Mr. Frenkel, in short form, had not gone away. But the second point, and the point that really answers your question, I think, for these proceedings, is that if I were standing here trying to defend a finding of the judge below that Mr. Frenkel had had a particular state of mind in 2010, that was contradicted by subsequent positions that he had taken and subsequent clear verified legal documents, I would have a problem. Mr. Twigger would be saying that finding about what Mr. Frenkel believed isn't one that the judge could properly have made because he shouldn't have and didn't purport to put reliance on the witnesses, and the documents directly contradict what the witness was saying. But happily for me, I'm not in that position because Mr. Frenkel's subjective belief is not relevant to this appeal. What is relevant to this appeal is a finding about Mr. Bell's subjective belief. So in my submission, whatever one can say about source for the goose and source for the gander, the real point is that the judge rightly said, I can't place any real reliance on the recollections of any of these men. What I have to do is look at the documents and the circumstances. And the point that I'm making is that the documents and the circumstances are very clear about what Mr. Bell actually thought as early as 2011 and 2012. And the problem for Mr. Twigger and the problem with the judgment below is that they have to conclude that between 2010 and 2012, Mr. Bell was not merely confused, but that he moved from having a clear understanding in 2010 that Inc. had gone and had no ownership interest, to making the clear statements that he did in 2012 and subsequently, that Inc. did in fact have an ownership interest and had had an ownership interest all along. And in my submission, in the absence of any other evidence pointing in the other direction, and there isn't any, that simply isn't a tenable or sustainable finding. So that's the Californian evidence, which Judge Jarman does deal with in his first judgment, and I'll take you back to that in a moment. The next is Supplementary Bundle Tab 5, pages 29 and 30. And the relevant message in particular is the message in the middle of page 29. So these are WhatsApp messages between Mr. Bell and Mr. Frenkel. And so this is a message from Mr. Bell in April 2012, so shortly after he gave the deposition. Mr. Frenkel has been harassing him for his share of the distribution on the US side. one thing which is happily not in dispute is that whatever the ownership position on the US side, whether it was owned by Inc. or whether it was owned by the two individuals, when distributions were made, they were in fact paid to the two individuals, half each. And what Mr. Bell is saying here is, Roman, trust your well, can I have your bank details, please, for payment? So Mr. Bell here is clearly indicating that he considers that Mr. Frenkel, whether personally or derivatively of Inc., has
Sorry, what page are you on?
29, my lord.
Ah, sorry, I thought you said 30. Mistake. Yep, thank you.
Yes, 30 is actually, at the top of 30, you see Mr. Frenkel's question.
Yes.
Can you send me my portion of the money? So Mr. Bell is clearly representing or making clear here that he understands that Mr. Frenkel does have an entitlement to a portion of the money. And again, that's flatly inconsistent with an understanding that only Mr. Bell and Mr. Lyampert are the co-owners. And that again is important because of the timing. It's only 2 years later. We can then move on to the 2015 proceedings, which Mr. Buck took you to some of the documents, so I will seek to avoid duplicating them. The key point about all of these documents is that in my submission they carry greater weight because of their formality. So these are produced, Mr. Bell having given his factual account to his lawyers, and in a number of cases they are formally verified as pleadings and the like. And in my submission they're all unambiguous, and none of them can be consistent with him having thought in 2010 what the judge found him to have thought. So in relation to Mr. Bell's defence, this is at tab 7, page 33.
So on that last point you just
Yes.
made, is the statement of truth signed by Mr. Bell personally, or is that his solicitor? I appreciate you would rely upon it either way round, but do you in fact know whether that's Mr. Bell's signature?
I don't know. I had inferred that it was because it says in brackets D2 and it doesn't state the name of a solicitor or their position with the firm or anything else, but I don't know for sure.
We think it is Mr. Bell's signature.
It corresponds to the signature on his witness statement at page 140.
I'm grateful.
Not that I'm an expert in handwriting or anything, but just looking at it.
It's sometimes questioned whether there is such a thing, my lord. So at page 34, I think the court was shown paragraph 7D, which was the essential pleading about what was agreed in 2004. So 49% Bell, 51% Inc. But also relevant in my submission is subparagraph E, which is dealing with the question of how distributions were to be paid. And the pleading there is that it's agreed that payments would be made out of the profits accumulated by LA UK in the following ratios: 50% to D2, that's Mr. Bell, D2's sum, and 50% to Inc. or Inc.'s nominees. So that was, and that was defined as Inc.'s sum. And that is important because if one then goes down to paragraph 16, so this is on page 36, about 2/3 of the way down, you will see that what's pleaded there is that D1, that's Mr. Lyampert, indicated on behalf of Inc. that Inc.'s sum was no longer to be paid as previously set out, which we've just been looking at, but was instead to be paid in toto to Mr. Lyampert. Mr. Bell was entitled to rely upon the same, and in fact did rely upon it. So what's being said here is that what happened in or after 2010 was not a change in ownership of the share in LA UK, but a change in how Inc.'s entitlement to a dividend was to be paid on to its nominee. I use nominee in the sense of a person being nominated rather than a nominee holder, I'm sorry. So what this is saying is clearly that Mr. Bell continued to understand that Inc. was the shareholder, hence Inc.'s sum, and the reason he was making payments to Mr. Lyampert was not because Mr. Lyampert was now the co-shareholder personally, but because Mr. Lyampert was entitled derivatively of Inc. So that is flatly inconsistent with Mr. Bell's case and the judge's findings on ownership. It's also inconsistent with what one might call the case about indivisibility, the idea that the profit share and the ownership couldn't be dealt with separately. Quite the contrary, what Mr. Bell is pleading here with a statement of truth is that that was exactly what was agreed, that Inc. remained the owner, but Mr. Lyampert told him that he should pay all of Inc.'s money to Mr. Lyampert. So this is all premised, in summary, on an assertion by Mr. Bell, and an honest belief by him, that Inc. was in 2010, when they adopted this practice, still the owner of the share in LA UK. And none of the points which are made about context or confusion or anything else in my submission can explain what's very clear in this document, produced seemingly on legal advice. The next document is the solicitor's letter, which is at tab 8. And I know that my lords have seen this, so I'll deal with it very briefly. As my Lord Justice Nugee pointed out, this is simply a repetition, in effect, of what Mr. Bell said in his statement of case. But it is striking that it's a further iteration of that. It's some months after that. It's written by the solicitors, and it's absolutely clear what it's saying. And this is
in terms, you point out, a statement of Mr. Bell's belief. Mr. Bell believes that LA Micro Inc. is the correct legal and beneficial owner of 51% of the shares and entitled to 50% of the dividends.
Well, indeed, my lord, and that is obviously the exact contrary of the belief that he's alleged to have had in 2010. The fundamental point about this, and I might be in danger of repetition here, but is that they are diametrically opposed, and the finding that Mr. Bell needed the judge to make to succeed was that he had a specific belief in 2010. So if looking at this, one concludes that it would be open to the judge to have concluded that in 2010 Mr. Bell didn't know the heck what was going on, that doesn't help him. The finding needs to be that the belief he held in 2010 was exactly the opposite of the belief that he expressed subsequently. And respectfully, we say there's simply no... One would require, perhaps I should put it this way, in the light of all these subsequent statements, one would require compelling evidence of his belief in 2010 to conclude that he did believe that in 2010 and somehow came to completely the opposite view 2 years later.
Or a compelling explanation for what you say is a 180-degree reversal of belief.
Exactly. And there is no such compelling evidence or explanation. The most generous explanation that can be given is the explanation that the judge seems to get himself to. And I think this is why Mr. Buck was submitting, I would say correctly, that the judge must have concluded that Mr. Bell was confused in 2010 as well. That, it seems to me, is the only explanation, short of a deliberate volte-face, that one can put on it. It just isn't credible to conclude that he believed one thing then and completely the opposite later. And that's what they would need to show. Now, in terms of his oral evidence, and I can deal with this very briefly.
Was there a witness statement that addressed this before we get to the oral evidence?
There was a witness statement, Mr. Bell. I don't think we have it in the bundle, I'm afraid. Tab 13, am I being pointed to?
Well, that's a statement in these proceedings. Isn't
Yes,
it?
exactly,
I
yes.
think my lord was asking about the proceedings before Mr. Tipples.
He was, and the answer is that witness statement, I think, is not in.
All right, not to worry. So you're going to take us to the oral evidence?
I was going to take you to the oral evidence, which is at tab 25. And do my lords have their internal page 101 of the transcript? Or does it start slightly later for you?
It starts later for me.
105.
105, let's pick it up from 105 then. So at 105 he was being asked about the distinction between, this is at the top of 105, the two individuals, Roman and Ari, and the US office or Inc., which he talks about in the buying context. And he says at lines 5 and 6, I refer to Roman and Ari as a sort of royal we partnership. They are Inc. In my opinion, they are one and the same thing. So I refer to them as partners as if they were Inc. And then on 106, towards the bottom from line 14, I ask him about what he meant by his answer in the US about ownership. And I ask him explicitly at 21, that reflects, doesn't it, that in 2012 you still considered him to be an owner. One gets the answer, as far as I'm concerned, Inc. was the owner. He then says discussions took place. And then the key bit is on page 107 from line 8. It's clear from this that whatever you thought the effect of those discussions, so that's the Frenkel disavowal, was, you didn't regard it as having the effect of stopping him being an, inverted commas, owner of the UK company. Via Inc., correct. You didn't say it was the three of us, but it's now just me and Ari. I think the answer shows that itself. So he was reaffirming there in 2017 on oath the evidence that he'd given in 2012. He was being asked expressly what his personal belief was, and that was absolutely clear. And then if my lords have page 109...
Well, just before we get to that,
Yes.
you then put to him what he said about the company's house position. He agrees that that's accurate. And then he repeats at 108, you regard Mr. Frenkel as the actual owner, don't you, or part owner? And his answer is via incorrect.
Yes, that's right. I'm grateful, my lord, but it possibly some duplicative cross-examination, but it does rather underline the point that he gave the same answer twice. And then on page 109, picking it up from line 3, I was asking him the point about context in California, and saying that he knew that this was an important question. And he says, as far as I'm concerned, I've given a sensitive and truthful answer. And he then says, so this is volunteer, this is not this is not a point being rammed down his throat. He says, I was just saying it as I believed it. As far as I understand it, myself, Mr. Lampert and Frenkel are the owners. But, well, I should have said via LA Micro Inc. So that's all perfectly clear as late as 2017 as to what his belief was. So the proposition that the judge has to have accepted, I think, is that Mr. Bell believed one thing in 2010, clearly, a different thing, clearly, between 2012 and 2017, and then sometime after 2017, reverted to the correct belief that he'd held in 2010. That has to be the proposition. And I note only that purported reversion in the form of these proceedings came in the context of the Santa Monica Agreement and the opportunity to buy one share off Mr. Lampert for what my client certainly believes to be a very heavily discounted price. It's only at that point that Mr. Bell's recollection changes. I refer in my skeleton to Mr. Bell's written closing, produced by Mr. Strelitz.
It looks as if the case that you were putting was that actually the agreement all along was that Mr. Frenkel would own shares personally.
Yes.
The US interests would. And that the idea it was going to be Inc. was something that was made up subsequently.
Yes, that was the case I was putting. Miss Tipples found that that wasn't right, that the agreement had been that it was Inc. all along. But the point is that Mr. Bell is repeatedly asserting there in 2017 that it's still Inc. And that's what is fundamentally inconsistent. Because all of those answers, if he really thought what he now says he thinks, all of those answers would have been, Harry and I are the owners, Raymond disappeared over the hill in 2010. Why are you asking me all this? But his answers are very clearly not that. And one...
It seems to me that this might go to questions of unconscionability as much as reliance. I mean, if there was reliance as found by the judge in 2010, there nevertheless seems to have been a conscious decision by Mr. Bell to put forward to both the English and the American courts the case that there continued to be an interest either of Mr. Frenkel personally in the US deposition or of Inc. after 2010. And that seems to me might well have a bearing on whether it's unconscionable or whether there is an estoppel arising now, though I don't think the point's been put quite that way.
It's not putting quite that way, my lord, but one might certainly step back and say the case against Inc. and my client is that they made, through the so-called Frenkel disavowal, a representation about ownership, which they should then be held to. One might ask oneself rhetorically whether the representation Mr. Frenkel allegedly made in the Frenkel disavowal was anywhere near as clear or legally certain as the series of representations that Mr. Bell made in the Californian and English courts in the opposite direction. So I would respectfully say that it does go not only to reliance but also to unconscionability. And it also goes, in fact, and I'll come back very briefly to this, but it goes to implied term as well. because one has to ask, and it is, I will accept a forensic point, but it's an important one, if it were really necessary or obvious that the ownership should change as a result of the trading relationship, why did Mr. Bell not think that had happened in 2012 or 2017? And that's where, in particular, the point about the pleading about Inc.'s sum is relevant, because it's clear from that that Mr. Bell and Mr. Lyampert fully understood the idea that you could treat ownership and profit differently, and therefore that it didn't follow that if one changed, the other had to change as well. Now, ultimately, of course, I accept that's an objective question, but it is forensically significant in my submission. Now, the written closing is at tab 9 of the supplementary bundle.
Incidentally, it's clear from the transcript that there was a witness statement, as you would expect, of course, which seems to have said something about these matters.
Yes.
You're cross-examining by reference to it.
Yes. So it was page 51 of Mr. Bell's written closing that I just wanted to pick up. So it's paragraph N towards the bottom of that page. And I take you to this because lest there be any suggestion there was ambiguity in what Mr. Bell himself said in the witness box, this was the construction his lawyers put on it in closing and invited the judge to put on it. And perhaps your lordships can read paragraph N to yourselves. So no doubt what Mr. Strelitz was saying then, that Mr. Bell had been saying. The last piece of evidence or analysis of the evidence that I wanted to take you to was in His Honour Judge
You could
Jarman's...
also, before you leave the
Yes.
closings, refer to paragraph 4, where Mr. Strelitz points out that in those proceedings, the claim that is not advanced is one which gives rise to Inc.'s registration as a 51% shareholder, and says that's aligned with Mr. Bell's evidence in respect to which he's been steadfast. And he picks it up again at the end and says, but that's not the claim that's been brought.
Well, indeed, my lord. That's the finding that the deputy judge made. She concluded that she ought not to grant relief to Inc. When Inc. wasn't before the court. But with respect, that isn't an answer to the points about Mr. Bell's evidence, because one isn't analysing his evidence as though it were a judgment.
My lord was suggesting it was a point in your favour, not against.
Well, in that case...
It was the reference to Mr. Bell's evidence being steadfast to the effect
Yes.
that LA Inc. effectively is entitled to be registered as a 51% shareholder.
Yes, I see, my lord. I'm sorry. The reason I was slow to accept the gift was that...
A healthy suspicion of usually a good thing.
The healthy suspicion of having been opponents for 7 years on this case, but also because obviously the legal submissions that were then made on behalf of Mr. Bell were that the deputy judge shouldn't grant that relief, and she didn't. But it's clear that what is said here supports the view that is what Mr. Bell was saying was the correct position. So in terms of what His Honour Judge Jarman said about this in his first judgment, this is tab 14 of the supplementary bundle. That would be paragraphs 28 to 30 are of particular relevance here. So this is on page 149 and onwards. And so this is his analysis of the oral evidence. 28 recounts briefly what your lordships have just seen, as does 29. But at 30, His Honour Judge Jarman talks about what Mr. Bell said before him. He accepted in cross-examination before me that from 2010 he understood Mr. Frenkel had left ink, etc. He agreed when it was put to him that he was then dealing with Mr. Liampet on behalf of ink, and these were in effect interchangeable. So that is what he was saying before His Honour Judge Jarman, at least in cross-examination, what he was saying was his understanding. And of course that is not consistent with the necessary belief, which is that ink has gone away. What he's actually saying is ink is Mr. Liampet is ink. And so that is not, in my submission, sufficient either on reliance or unconscionability.
In paragraph 31,
Yes.
which is the cross-examination during which Mr. Bell is saying that he was confused? Is it the deposition in the States, or is it the cross-examination in the 2015 proceedings here?
My reading of that, my lord, and my recollection of his evidence is both.
Because the next sentence goes on to say, explain the deposition.
Yes.
So it rather sounds as if it might be that.
Yes, but the words that cross-examination most grammatically refer to the cross-examination before me, referred to in paragraph 30. So
there's three lots of
yes.
evidence. There's the US deposition,
Yes.
there's Miss Tipples, and then there's Judge Jarman.
Yes.
And in paragraph 30, he's clearly talking about cross-examination before Judge Jarman in these proceedings.
Yes.
But then he's talking about seeking in his evidence in these proceedings to explain his earlier evidence by saying that he was confused during that cross-examination.
It looks to me as if it's the cross-examination by Mr. Barden on behalf of Mr. Frenkel in the hearing before Judge Tipples referred to at paragraph 28.
Yeah, it may be.
Which is the one you've just shown us.
Yes.
I'm just wondering what the indications of confusion are. Obviously, the judge has the feel of the room and the view of the witness as to whether he's confused or not, but it's not apparent that a great deal of confusion is apparent on the face of the transcript.
Well, no, and of course, in relation to the start of all of this, which is the evidence in California in 2012, the Judge Jarman, no fault of his own, didn't have the feel of that because he wasn't there, and he wasn't there before Deputy Judge Tipples either. So, and the other problem, of course, with the subsequent confusion explanation is that the other documents, for example, the pleading and the solicitor's letter, are not subject to any of these points about pressure of being in a room or being pushed by an American lawyer or by me or by anyone else. Those are clearly produced carefully, taking time and with the benefit of his own legal advice.
I mean, the transcript of the cross-examination before Miss Tipples is not, as it were, you confronting him and trying to get him to go back on something. It's just a bit of a love fest where you're trying to get him to agree with what he's already said. And you do.
Yes, yes. But then, yes, Judge Tipples concluded that she wouldn't grant relief for ink.
Yeah.
And then when ink turned up and said, actually, I am entitled to that relief, Mr. Bell changed his position 180 degrees. And that's That's the problem. Now that's all the evidence I wanted to show you. I see the time.
Yes.
I have a few submissions which I suspect I can shorten over the short adjournment on the way the judge dealt with things. So I would hope not to be more than 10 or 15 minutes.
Very good. All right, we'll rise now until 2 o'clock.